Good evening, Mr. Chairman, members of the Planning Commission. My name is Heather Kelly. I'm a planner in the Planning Division in the Department of Planning and Growth Management here at Charles County. I am bringing before you an application on behalf of Mr. G. Croft and his engineer, Lorenzi Dodds and Ganell, for a revision to a previously approved preliminary subdivision plan for Hunter Springs. And I do have some prepared remarks just to keep me focused on the main highlights of the application, and then, of course, we're available for questions. Okay, and I'm just going to bring up some maps showing the location of the property. You can see that the property is off of Maryland Route 344, which is also known as Chickamuxon Road. And we have a zoning map from the Charles County zoning maps. This is an illustration that shows the agricultural conservation zoning of the property. And this is an aerial photograph of the site. So just a little background. Again, this is a revision to a previously approved plan. The revision consists of revising a previously approved conventional subdivision of 17 lots into a cluster design subdivision, which will now consist of 27 lots. The main distinction between the conventional and the cluster subdivision is that the cluster subdivision will have at least 60% of the total tract area contained within open space. Like I mentioned, the parcels subject to the project application are zoned agricultural conservation, AC, and the project is accessed from Chickamuxon Road. And we have staff from the Resource and Infrastructure Management Division to provide an analysis of adequacy of public facilities for the project.
Okay, thank you, Heather. For the record, my name is John Mudd. I'm the Resource Manager with RIM under PGM, and I'll briefly go over the APF project consistency findings for this revised plan. Excuse me. First, under roads, we will note that the applicant submitted a new traffic impact study showing the impact of the proposed 27 lots on the intersection of Maryland Route 344 at the site access. The study showed that the intersection will function adequately under future conditions and meets the adequacy standards of the zoning ordinance section 257. Again, because 344 is a state highway, we note that the State Highway Administration has imposed the requirement of auxiliary lanes in the form of deceleration and acceleration lanes at the project entrance. Staff notes that these auxiliary lanes will serve to separate conflicting vehicular movements and will add to the suitability of the intersection to meet the current standards. Under the topic of schools, we'll note that the remaining unallocated lots would be placed on the school allocation waiting list upon approval of the subject subdivision. Under groundwater supply, we will note an error in the staff report that you have before you. It was an editing problem. The correct title should state that the project will be required to obtain groundwater appropriation permits from the Maryland Department of the Environment for the proposed on-site wells, as this project is in the more rural portion of the county and is not available to connect to the public water system. Under rural fire suppression, we note that the project is required to meet the standard. This particular plan has satisfied the requirement by their proposed provision of a 30,000-gallon underground fire suppression tank near Station 2+0 near the entrance with Deer Creek Court. The Nanjemoy Fire Department has reviewed the plan and has found the proposal to be acceptable. To that end, staff is recommending a condition, which I won't read, but is contained within your report, that basically looks to ensure that this facility will be constructed commensurate with the subdivision road for the project. With regard to secondary access, because the project will produce far fewer than 1,000 vehicle trips per day, and therefore a secondary access point is not required or warranted for the subdivision. And with regard to Section 75A, B, and C, which are road improvement requirements through the subdivision regulations, we'll note that these provisions are not applicable as, again, the project fronts on a State Highway Administration roadway. And finally, then, RIM would determine that the proposed preliminary subdivision plan will not adversely affect the adequacy of public facilities serving the area, project, or development as specified within Article 16 of the Charles County Zoning Ordinance, subject to the recommended condition.
Thank you, Mr. Mudd. And just for the record, the oversight with the groundwater appropriation permit was my fault. That was a little copy and paste error, so don't blame Mr. Mudd. That was me. Just a few other points here. The Hunter Springs application is addressing forest conservation requirements with proposed on-site forest conservation easements. You'll also notice there was an aspect of mitigation for recorded easements that need to be revised if the proposed preliminary plan revision is approved. Some other items that we base our review on: the county's contract archaeologist concurred with the Phase 1 archaeological assessment for the property, which did not recommend any further archaeological work. The Hunter Springs application will not contribute to exceeding yearly goals for the number or type of dwelling units outside of the development district. You'll see in your staff report this evening there's a summary of various calculations and numbers based on references in the comprehensive plan about population growth and household size, and that's what we base this finding on. The open space requirements for the cluster development have been met. You'll see there's an analysis of superior design in the report. There's 14 items. The applicant and staff work together to try and have as many of those items addressed as we can. You'll also see stormwater management has been addressed with this particular project with an administrative waiver. You'll see some of the criteria for the waiver in your staff report, and that is something that's granted by our Codes, Permits, and Inspection Services Division. They did note that future individual building lot development is going to address environmental site design to the maximum extent practicable, the ESD to the MEP. In conclusion, staff recommended approval of the preliminary subdivision plan subject to the two conditions that are in the staff report, and one of those refers to the required 30,000-gallon fire suppression tank. And then there was another condition about potential easements for the common access easement that will contain the private drive within the development. And that's the conclusion of staff's presentation. I know the applicant's representative is also here this evening for questions if necessary.
Questions?
I have a quick question. I'm not quite sure if you're going to be able to answer this or not. I see that the original Planning Commission approved this 13 years ago, and then I believe 8 years later there was an adjustment to change it from 16 lots to 17, and now 13 years later we're jumping up to 27. Is there a reason why it took so long? Is there a reason why we're jumping from 16 to 17 to 27?
Probably the applicant could best explain their potential reasoning or the time delay. From our perspective, you know, it's a design into just another permitted form of development. You know, going from the conventional subdivision to the cluster subdivision. The choice would have been a personal choice on the part of the applicant. So maybe if we wanted to know, they could come up and explain. Or
okay.
Is the applicant here?
Mm-hmm.
Hi, Tim Lessner with Lorenzi Dodds and Gannell. My firm did the preliminary plan revision for the 27 lots, so I think I can answer your question. The original preliminary plan was approved many years ago. There was a previous engineer involved who subsequently went out of business, so my client was stuck. He hired another engineer who finally got it engineered and took it to 17 lots. I'm not so sure what the reason was to go from 16 to 17. Basically, at the time, it was a conventional subdivision the lots ranged from 3 to 4 acres. A year or two ago, well, actually, those lots were recorded, and I think in your packet are copies of those recorded lots of the 17. It was permitted, it was bonded, and it's actually under construction. So there was a development services permit issued for this road as it is shown right here. A couple years ago, when my client wanted to pursue the possibility of adding 27 lots, or adding 10 lots and changing it to a cluster, that's when I got involved. To make a long story short, what we did was basically utilizing the same road that was previously approved under the same development services permit. We decided to try to go out and do some additional perk tests, which of course we did. And what this plan does is utilizing the same permit, the same limits of clearing, same limits of disturbance. We added those lots, changed the forest conservation. Instead of probably 6 or 8 or 10 smaller segmented easements that were separated from one another, we put all the forest conservation on the open space, made large chunks, large bands of forest conservation. Of course, those areas are protected in open space also. To answer your question, the reason why we did it was to get more lots, of course. That whole 13-year period that went in there, as I said, there were 2 other engineers involved. There was a recession involved when it was permitted or ready to go in 08 or 09. Nothing was selling. It made no financial sense to move forward with the project. And now when I got involved, it seemed to make more sense to make it a more environmentally sound project. The stormwater management waiver that was issued with the original project was for the road. As part of the negotiation with the current stormwater management engineer, we've agreed to do ESD on all the individual lots. So this project, in my opinion, is a much more environmentally sound development. I hope that answers your question.
You did. Thank you.
Ms. Shertler, I think you had a question, and then Ms. Jones.
I have a couple of questions, and you mentioned the waiver, and can you explain that? The stormwater waiver number 26, you said it was for the road?
Well, for projects that were approved, meaning stormwater management and sediment control, if those 2 issues had been approved by the appropriate agencies prior to, I believe it was May of 2010, maybe it was 12, I'm sorry, then you could apply for a waiver, meaning you did not have to meet the ESD to the MAP, the new stormwater management regulations. This project met that requirement and met that time frame. Many projects have. You probably have or will hear that quite a bit. But like I say, as part of the negotiation with the current stormwater management engineer, we agreed to do ESD on each of the individual lots. So
You might want to explain what that is, ESD.
Well, it's the current,
What
it's
it
the
means,
current
what it
stormwater
means.
management
ESD.
regulations. It's a much more in-depth study for stormwater to control runoff, for infiltration and bioretention, and I mean, it meets the current state regulations.
Got it. Okay.
Okay.
I have a couple of other questions. I don't know if you can answer them. I may have to go to Ms. Daly. There's a talk in this about tier stream order, and I understand the tiers as far as septic goes, what they mean, but the orders for streams I'm not clear on, because I believe there is a tier 2 stream on this property, if I'm not incorrect. So I was just wondering what that, if I can, and I don't know, I don't want to make you guys play musical chairs. But
Go ahead.
Hi, I'm Amy Daly with the Department of Planning and Growth Management. I'm a planner. You've got 3 different items that you're dealing with in that statement. You have stream orders, which basically define what type of stream they are and how they're regulated, and then you have the septic tiers 1, 2, 3, and 4. And then what you're talking about specifically with Hunter Springs is that there was a designated Tier 2 water in the Hunter Springs subdivision area, which I mentioned in the finding for the habitat protection, how they've expanded the resource protection zone to encompass a little bit more for that Tier 2 buffer. And basically Tier 2 is a designation by state or federal agencies that it's more of a pristine waterway, and there's that extra buffer or extra protection. And as part of their habitat protection, this applicant has chosen to expand the resource protection zone, which is allowed under our ordinance and basically encouraged and required as a habitat protection measure. They've expanded to the Tier 2 buffer, which is normally something regulated at an MDE level, Maryland Department of the Environment level.
And Tier 2 is more pristine than Tier 3? I'm just not sure which way we're going.
I don't know that there's necessarily a Tier 3 designation, but the Tier 2 waterway is something that's determined to be of a pristine or high water quality, and they have a goal of protecting those areas. Did you want to add anything, Mr. Leslie?
Okay.
I mean, that's a pretty good explanation.
Okay, yeah, because there's something, and I didn't mark where. It says that an order of 3 stream has a 100-foot buffer, and an order of 2 has a 50-foot buffer.
Okay. Those orders are about how the stream is made or what comes together to create the stream. And that's how we determine at Charles County what size buffer we apply to it. An Order 1 stream and an Order 2 stream are the smaller streams. 2 Order 1s come together to make an Order 2. Then 2 Order 2s come together and make an Order 3. And there's a hierarchy of streams as they come together and what they create. And your 3s and 4s are your larger stream beds. Your Mattawoman Creek, Potomac River. The largest stream order we have is a 4. So the larger streams in Charles County are 3s and 4s, and they have the minimum 100-foot buffer from the edge of channel. Okay. So some streams have that, and that's how we determine our buffer. So that's a different classification than what MDE would be regulating. Okay. It's kind of a universal way of classifying a stream body.
Okay, I think I have it.
And I can provide more information.
Okay, that would be great. So I'm still a little confused, but that's me. I have another question, and again, it may be to Mr. Lesner. In the packets, and actually on sheet 2, there's a letter dated 2005 from the Department of Natural Resources that says, and I'm not going to read the whole thing, it says the Department's Wildlife Heritage Services has no records for federal or state rare, threatened, or endangered plants or animals within the general area of the subject property. It continues to say, this statement should not be interpreted as meaning that no rare, threatened, or endangered species are present. If appropriate habitat is available, certain species would be present without documentation because adequate surveys have not been conducted. So my question is, have adequate surveys been conducted in the last 10 years since this letter was written?
That letter is a blanket format from the Department of Natural Resources to state that they currently don't have documented records of species, but it does not imply a requirement to a project to conduct assessments. There is an inherent requirement that if the applicant were to begin construction and encounter a certain species, that they would have to basically stop work and coordinate with the Department of Natural Resources to protect the habitat. But that letter does not imply any further requirement on behalf of the Department of Natural Resources. So when we require an environmental review under forest conservation law, the letter from the Department of Natural Resources that says we have no records is basically saying at this time we have no record and we have no requirement.
And I know it's too late for this project because the road's already cut and the FID's habitat's gone. But if you look at, the DNR's website, the Merlin Online, which has all the different layers, if you look at that, you'll see that this is a green infrastructure hub on the green infrastructure. It's a DNR targeted ecological area. It's a FID's habitat, and it's within 1,000 feet, if I'm doing the little measuring thing right, within a sensitive species project review area. So I guess my question is there any way that the county can trigger a request to do a survey. I mean, if you don't look for it, you're not going to find it. And is that something we should consider?
Under the current codes that we have, I'm not aware of any ability that we have to compel a survey
Okay.
with that type of comment from the Department of Natural Resources.
Is that something we could do?
Well, what about the forest conservation? Do they do inventory work with the forest conservation plans, or is it just for the trees?
Well, the Forest Conservation Plan was the trigger to require the Department of Natural Resources review. That's a part of their components of requirement to prepare the plan, the environmental review. And so that is incorporated into how we, meaning the county and both the applicant, are looking at the forest areas on site and determining where the preservation should occur. Beyond that, there's no additional assessment requirement for habitat to be compelled or to be required of the applicant.
Okay.
We look at the priority areas, we look at the stream areas, but if the Department of Natural Resources sends a letter of that nature,
It says when we didn't look, and if nobody looks, we're not going to find it.
we have no way of compelling further searching at this time.
That's the questions I have.
Ms. Jones?
Anna Minor, and you may answer. With the historical and archaeological issues, the question is just that it says that the contract archaeologist concurred with the recommendation of the archaeological assessment. Is there a time at which the Historic Trust needs to get involved for their opinion or not?
I'll defer to Mr. Lessner.
I'm not asking that they do. I'm just asking what generally is the case.
As you may or may not know, just about every project requires at least an initial archaeology assessment. Mm-hmm. This project had it. It's called a Phase 1A. The Phase 1 recommended an additional study. We did the additional study and found that there was nothing on site. What's not mentioned in here is that there was concern, apparently in some old deeds and whatnot, that there's a cemetery close by. What's not mentioned in here is that we did deed research looking for that. It's not on our property. It's behind our property, and we provided pictures and documentation and deeds and whatnot to the county staff to give assurance of that fact. In fact, we located it so that the county would have an accurate location of it. As far as archaeology on site, to answer your question about Maryland, I think the Maryland Historical Trust, the trust normally wouldn't get involved unless
I meant
there's...
the local Historic Trust, Charles
Well,
County.
again, if you do a Phase 1, archaeology Phase 1 study, and it recommends either the possibility of a moderate or a high potential for additional findings, then you move to the next step. When you move to the next step, there's certain requirements that you do, and if you find things, then you move to the next step. There was nothing more to find. Staff concurred with that assessment. And the only question they really had was about the possibility of this, I think it's called the Gibbons Family Cemetery. Well, like I say, we did the necessary deed research and located it and provided proof that it is, in fact, off-site.
Mm-hmm. Is that something, and I accept that it's not on this property, so it's not relevant to it, but for cemeteries near subdivisions, is there anything like, is there someone, the county or whomever, that might at least try to protect it with some type of fencing?
Well, we've had several projects that have cemeteries, old cemeteries on the property. And as you may remember, just a few weeks ago, I think Beth Groth or Kathy Thompson brought to you a cemetery that was on one of the projects I worked on called Turtle Creek. And we had found that cemetery 15 years ago when we initially worked on the project. and we prepared a cemetery preservation plan and presented it to the staff, which of course that was presented to your board a few weeks ago. And that project, in fact, we put a fence around it and did all sorts of things for it. And it's like this. It's part of an open space within the neighborhood. And I believe that was one of the first sites that has been approved as a historical landmark, so to speak, with the county that you all approved. So the answer to the question, again, is that if there are cemeteries, they are found and assessed during the initial review and during the forest conservation, forest stand delineations, and most cemeteries in the county have some documentation on them already. Just like this, there was some documentation that it was close by, so we assessed it, we found it, and provided documentation to the county for it.
So who, if anyone, would be responsible, or is there any concern that it be protected?
Well, that's what your whole code is for now, so to speak, and if there's something there, we'll find it and we'll protect it.
You mean?
But you have the Historical Preservation Board, that if we had found it on this property or some other significant
No, I know it isn't on your property. Since it isn't and it's nearby, is there something that...
I suppose if the county planning office wanted to pursue it, if there was ever a potential subdivision on that property, then you have record of it now that you could pursue it and have it protected. I mean, we can't do anything about it.
I understand.
I suppose the county, if they found that if it was significant enough, that they could approach the landowner and ask for more additional perpetual protection for it. But most likely, I would think that you're just going to wait until there's possibly a subdivision or some type of development proposed. Then you would have the opportunity to move forward with additional protection.
That's fine. My last question is just, can you tell me how, with the 10 lots that are unallocated with respect to school vouchers, whatever, how that is done? Is there no building on the lot until, or just how?
That's correct. You want to go?
Sure. As we may have mentioned before, a plat of subdivision cannot be recorded, cannot be signed for recordation unless school allocations have been duly granted to that project. So it goes even beyond a potential building permit. The lots are not allowed to be created until such time as an allocation is granted.
So with the remaining, though, the 17 could be?
It's definitely our intention to record the 17 lots because we already had those allocations. The other 10 lots, once this preliminary plan gets approved, will go on the school capacity waiting list. And then twice a year, the county, that's John's department, assesses the situation with the schools, elementary, middle, and high school. If there is capacity in those three schools, possibly an allocation would be offered to the project. If there is no capacity in one or all three of the schools, it stays on the waiting list, and our only option would then be to apply for a DRRA, which is the Developer's Rights and Responsibility Agreement, at which point in time that's a whole process in its own. But in the meantime, we do plan on recording 17 lots, and I would think at least out in this neck of the woods, that'll probably last us a few years.
But if you might get, say, 3 of the 10, you could record and build on those 3.
Yes,
then
ma'am.
you'd be waiting for 7.
Right.
Oh, okay. That answers my question.
Okay.
Any other questions? I have one, and maybe Mr. Lesner can clear it up. The 6 panhandle lots. Would you explain to me, or maybe staff can explain to me, and maybe the rest of my colleagues, the meaning of a panhandle lot?
Well, a panhandle lot, if you have the plan in front of you, or perhaps we could dim the light and look up here again. For instance, lot 1 and lot 3 are panhandle lots. A panhandle lot, according to the code and definition, is basically it's a lot that doesn't have the necessary road frontage, like 100 feet or 150 feet of road frontage. It has to have a minimum of 12 and a half feet of road frontage. So therefore, then you can have a panhandle, a strip of land that connects the buildable portion of the lot to the public right-of-way. In this case, for instance, Lot 3, it has a strip of land that connects. Now, in this case, they can be 12 and a half foot wide, which, most of your driveways are 8, 9, 10 foot wide. So theoretically, you could build a driveway in a 12 and a half foot strip of land. In this case, I think I tried to make them at least 20, maybe 30 foot wide. They're wider than 12 and a half foot, and that therefore we have room to grade, to mow, a little landscape strip or whatever for the folks that moving into those lots. You could also have a situation like back toward the back on the cul-de-sac on that little private street that cuts off to the right. Those lots in particular, those flag lots or panhandle lots are probably only 12 and a half foot wide, but there's 1, 2, 3 of them back there. So they will jointly have a joint maintenance agreement over top of those strips of land, so that those 3 or 4 people that utilize that private road, they will jointly have an access easement, and there'll be a joint maintenance agreement so that those 3 people, not the whole neighborhood, but those 3 or 4 people that live on that private road will have to maintain that, like perpetually maintain it if there's ever a problem with it. Most developers set up a little road club or something like that to pay for future maintenance, and then they would feed into it also. But there will be an easement with a maintenance, perpetual maintenance easement over top of it. So that's not a county maintained road. That's a private road.
Another question I have, and Mr. Ball can maybe help me out. Didn't this body discuss safety measures within the development that would avoid traffic from exceeding a certain speed limit to minimize any type of undue incident such as an accident?
Yes, we have new requirements and design options for what we call traffic calming measures. Those are in the process of being adopted right now. They haven't been finalized with the county commission. In this case, there's not enough lots that would warrant such improvements.
Just asking.
Mm-hmm.
Thank you.
I did have one question. I had taken a look at the design and was wondering, is there any, and I couldn't find anything, but any requirement or desire to have more than just one access to this cluster development? It seemed like it would, add a little more safety if there was at least another way to get in and out of it. And I don't know I couldn't tell from the pictures if that was even possible to engineer that. But was there any concern with that?
Well, that is what we call interparcel connections. Staff, during the technical review committee process, when we submit a preliminary plan, that issue usually comes up. Generally speaking, if you're over, I think it's 100 lots, you have to have a second access point. If it's under that, especially if you're 20, 30 lots, this is my opinion, staff can certainly say what they want, we are usually required to assess that situation. If you look at this property, to the left, or I should say to the west, there's an environmentally sensitive area down there. There's a large wetland and resource protection zone, and there's subsequently a stream on the neighbor's property. The same thing to the rear. It severely drops off in the back. There's wetlands, there's resource protection zones. To the right, there's several small parcels. Highly unlikely that If they're developed, they would need an interparcel connection, so to speak, with a public road. I think that's probably the best explanation I can give you. Again, this is a previously approved subdivision with 17 recorded lots. The road is recorded, the right-of-way is recorded, and as I said, the road's under construction, there's a bond posted, it's cleared, it's graded. We were never trying to increase disturbance here. We were never trying to increase impervious surface with additional roads. We were always trying to utilize the existing permits that we had.
Thank you.
Yes. Ms. Shertler.
I have one more question. If the 10 new lots aren't approved, you still need the tank for the fire suppression?
Yes.
That's correct.
Okay.
Any additional questions or comments? Do I hear a motion to approve or disapprove this preliminary plan, Hunter Springs?
I'm sorry. I thought we were going to have it. Is there going to be a discussion about it that's not involving questions for the applicant, just amongst the board?
Sure, go ahead. That's why I asked if there are any more comments or
okay.
questions.
Okay. Before a motion, my concern is that the applicant has not met the requirements in the code for cluster development, because what we're looking at here is a marginal increase in the number of forest conservation easements and an addition of 10 septic systems and a very small path adjacent to Chickamuxon Road. And the increase in the impervious surface of the additional buildings. And I don't see, and since one of the requirements is that the cluster development plan and the preliminary plan of subdivision provides for a total environment and design which are superior in the reasonable judgment of the Planning Commission to that which would be allowed under the regular regulations for conventional. So it seems to me that the 27 is not superior to the 17 that we have currently approved.
Any additional comments remarks before we go any further?
My comments
Jones.
are just that based on the fact that the planning staff have reviewed this preliminary plan extensively and is finding that recommending approval of it, including the cluster subdivision findings. I don't know that we have information that would preclude or throw out what they have done. And I would certainly not be recommending disapproval based on that.
Well,
Go ahead.
It does seem that the requirements for cluster development in many cases are the minimal when you look through the list. And so I don't think if you're minimally making the requirements, and again, we're tasked. I mean, the zoning ordinances tasks us to make sure that it is superior, and I just don't think it can reach. I don't think it reaches that threshold.
Mr. Chair, if I may.
Yes, Mr. McGowan.
I frankly kind of like what they've done with the forest conservation. The old plan sort of had little tiny clusters of forest conservation to make up for all what they needed. And now it strikes me that this is sort of protected and there's a nice buffer all the way around this thing, and it just it seems like a efficient use of a piece of property to me. And I don't know that I could go with disapproval either. I like how creative you were, really, with the flag lots. I'm sorry you call them now what? Panhandle lots? I don't see an issue with it.
If I may,
Sure, go right
I
ahead.
don't know if it'll address the concern, but I would say that as far as the superior design criteria, which you're going to hear a lot about that in all your cluster subdivisions, I believe that that's a guideline, and we all try to do the best we can to come to an agreement with staff on what is considered superior. I believe the only, I'll say, disagreement was, I don't even know if it was a disagreement, but staff was suggesting we have an interior loop, so to speak, with a hiker-biker path. I, on the other hand, looked at it that if folks want to utilize the open space, that there's plenty of open space. I wouldn't want to limit it to them in the interior on one specific loop. I looked at it that a more appropriate design would be to try to do some type of interparcel connection, a pedestrian interparcel connection. Of course, this is all private property around here, so I put the hiker-biker, not the hiker-biker, but the walking trail, the nature trail, basically along the road frontage, and kept part of it, if not most of it, in the forest conservation easement. And it would be my idea that rather than create a paved path of some type, to kind of create a nature trail with some signage for wildlife. We've done that. This is far, far above anything that you would have seen if it was just a standard 17-lot conventional subdivision. Most of our subdivisions in the last 10 to 15 years, the whole push is to try to get the forest conservation off the lots so that the individual homeowners don't have the opportunity to cut down trees in the forest conservation easement. Here, all the forest conservation is on the open space off the lots, so they can't go cut the trees down in the open space. We have provided other, what I would believe or consider superior design. This particular neighborhood, instead of having individual mailboxes, we're going to have kind of a central location up near the water tank where there'll be a sitting area, some benches. It'll be the bus stop area. Although the cul-de-sac is large enough for buses and emergency vehicles, there'll be a bus stop area up front with the cluster mailboxes there also. Again, far and above what the conventional 17 lots would have done. These lots will have to do ESD to the MEP. The conventional lots would not have. There's a lot more forest conservation here than there was on the other plan. I would offer that this is a far superior design than the conventional.
I think it's one of the more superior that I've seen come across this body since I've been on here, and I think it's very good in protecting the environmental steep slopes and stream valleys.
Thank you.
So for the discussion, I would just add, looking at the superior design criteria of the 14 of the ones that do apply, I mean, in their totality, I think it's a very nice design. I do like how you've taken a look at, the forest conservation, water conservation, et cetera. So, for the discussion, I find that it is, in its totality, looking at the different criteria, I think it's a pretty good design. I probably do agree with the staff about the interior loop, but other than that, I think it's a great design.
Ms. Jones?
And I just want to say, on page 12 of 13, on the same, what Mr. Barnes is speaking of, where it talks about superior design criteria summary, staff report says that the applicant appears to have demonstrated compliance or partial compliance with 10 of the 13 potentially applicable elements, and then item 3 is not applicable, and the item 12 interpartial connections and 13 are potentially not applicable, and 6 appears to meet the criteria. So I think the staff report suggests that the superior design criteria has been adequately met.
Any other comments? If not, then let's move forward with some kind of motion, please. Staff, do you have anything else?
Nothing else unless you have further questions.
Ms. Jones? Oh,
Just one other question. If this were to come before us as a brand-new development, and I know it's not, this would have to, because it's in Tier 3, would have to have a public hearing, correct? Because of the number of, because it's Tier 3 and the number of houses proposed?
Well, if it is in Tier 3, I'm not certain it is in Tier 3. It could also be in Tier 4 area.
This is actually a Tier 4. If
It's
you're
a Tier
looking at the septic,
Yeah.
yeah.
So,
This is actually a Tier 4, so the answer to your question is yes.
yeah, okay.
Yes.
anyone else?
Tier 4 would not,
Tier 4, you can't have.
you wouldn't be able to have that many lots.
Right.
So there would be no public hearing.
Well, it is possible that you might see a major subdivision in a Tier 4 based on the fact if they had met the initial grandfathering clause that they had to apply for septic or perk tests by July 1st of 2012. And if they had met that and then they have a preliminary plan approved by October of 16, it is possible.
Yeah, it's possible.
Right. Yeah.
I mean, that's essentially what this project
Yeah,
is.
and I do understand that. I guess my point is that the reason for the septic law is that developments this large on, we're trying to move away from developments of this large on septic, which then begs the question, is this superior? And is it for total environmental design?
Ms. Jones?
I move that the Planning Commission approve the preliminary subdivision plan entitled Hana Springs XPN number 97-0020, and that the Planning Commission find there are adequate public facilities to support the project, and that the Planning Commission adopt the findings and recommendations incorporated within the staff report dated March 23rd, 2015.
Motion's been made and seconded. Any further discussion? Hearing none. All in favor of the motion. Does everyone understand the motion? All in favor of the motion signify by raising your hand and saying aye.
Aye.
Opposed?
Opposed?
Ayes have it, and so carried with one opposition. Thank you, staff. Thank you, Mr. Lesner.
Thank you.